Hi, my name is Julie Starkey-Dean, and I'm going to be discussing the case with Emma, Mr. Jones, and Mrs. Potts, and the incident that occurred at the Hot Spoon. So I would initially be Emma's attorney, and I would welcome her into my office, and I would try to comfort her and console her because this is a matter that is very damaging to her. I would welcome her in. I would probably hold her hands and know that I'm consoling her in this matter and that I'm going to listen and be very communicative during this time. I would ask her if I could record this this discussion so that I could focus 100% on Emma and not have to worry about taking notes. But by the recordings, I could go back and take the time and listen and take notes at that time. I would first ask Emma what was the date that the incident occurred and the conditions of that day. I would then ask how has the incident affected her physical appearance and her daily life emotions. Third, I would ask if the soup being spilled has affected her employment. And then I would ask a few additional questions to go into the depth of pain and suffering. And those questions would be, is she married or has a significant other in her life? And has that affected her relationship? I would then ask, how is her emotional state since the incident? And are the injuries affecting her ability to function daily? And has she had depression? After this initial interview, I would then have a discussion with the opposing counsel, both Mrs. Potts and Mr. Jones. I would first speak with Mr. Jones' attorneys and start the discussion out with in what direction are they heading with this case. I would ask, is Mr. Jones accepting any responsibility for the matter that ultimately affected my client Emma? I would then ask, is Mr. Jones willing to move forward with a settlement agreement for my client's injuries due to the hot soup that splashed on Emma during the incident, causing burns on her body? I would also ask, does Mr. Jones realize his negligence in this matter? Another question would be, are your intentions as Mr. Jones' counsel to expedite this matter? Have you discussed negotiations with Mrs. Potts' counsel? And if so, how did that discussion go? Was it an excellent discussion, or just a good discussion, or a potential court hearing? After I completed the interview with Mr. Jones' counsel, I would then contact and have an interview with Mrs. Potts' counsel. I would discuss the case against my client, Emma, and then I would also ask, is Mrs. Potts willing to negotiate this matter with my client? And does Mrs. Potts understand the physical burns that attributed by her falling into my client? What level of responsibility do you see with your clients versus my client's physical burns? Are your intentions as Mrs. Potts' counsel to expedite and settle this matter? Have you discussed negotiations with Mr. Jones' counsel? And if so, how did those discussions go? Once I completed this information, I would weigh the pros and cons. If it went to negotiations, I would negotiate Emma's potential liability first, and my proposal would be one that Emma is not liable for the dog bite that occurred to Mrs. Potts because this restaurant is dog friendly with a particular area for customers' dogs. So if Mrs. Potts is entering a facility that she knows is dog friendly, then to me it would be difficult for her to claim this issue with Horton. I would argue that Horton has not had any prior cases of biting anyone. I would also argue that Mrs. Potts entered a restaurant with the knowledge that it was dog friendly. I would then place blame on Mrs. Potts for failing to take the safe cautions of walking into a facility knowing that it was raining outside. I would also use the modified comparative fault rule that Mrs. Potts is at a minimum of 51% at fault for causing the accident that occurred, and with this rule, Emma would be ruled at no fault and no liability. As far as a joint and several liability, I will argue that Mrs. Potts be liable for the negligence of not being careful while entering the hot soup. Which also caused burns on 15% of Emma's body. I would create a settlement offer first with Mrs. Potts for the amount of $200,000 for pain and suffering, lost wages, and medical bills. If Mrs. Potts' attorneys come back with a no response to the offer, I would negotiate an offer of $100,000 based on a response from Mr. Jones' attorneys and $100,000 for Mrs. Potts' attorneys. I would write up a settlement offer for Mr. Jones' attorney stating that if a sign would have been placed at the entry of the restaurant, that Mrs. Potts would not have slipped and fallen into Emma, causing the burns. Next, I would state that if this cannot be settled, then we would further have to have discussions either in other elements or take it directly to court. The potential advantages of this negotiation theory are that a split settlement between two parties would then come to terms for the settlement for Emma. The potential disadvantage is that if both Mrs. Potts' attorneys and Mr. Jones' attorneys feel that neither of their clients are liable, then it would definitely have to go to court trial. If we were to go to mediation, I would, while representing Emma, I would gather as much information and interview witnesses. I would discuss with Emma what her desirable outcome is. I would keep an open mind and discuss being open-minded with my client and assuring my client receives an adequate payout and leave her a no fault. As long as Emma is on board and how the mediation process will flow and that she will end up paying some fees for mediation, then it would be to her advantage. During mediation, making it clear to both Mrs. Potts and Mr. Jones that Horton would not have chosen to bite Mrs. Potts if the following had not occurred. If Mr. Jones had placed a sign acknowledging that the floor was slippery, and if Mrs. Potts had been more careful as she walked into the hot spoon that day, she would not have slipped across the floor into Emma, knocking her hot soup onto her, causing 15% burns onto her body. Also, if Mr. Jones had complied with the legal height limit of the fence surrounding the dog play area, then it may not have potentially caused Horton to jump in reaction to Emma screaming out in pain. If all three issues had not occurred, Mrs. Potts would not have caused the chain reaction that occurred, causing Horton to bite her in her derriere. It is a healthy animal instinct to protect its owner, and that's exactly what Horton was doing. Another main point in this case is that if Mr. Jones did place signage, then maybe Mrs. Potts would have walked in a little more carefully. There leaves no room for concession on these points after argument. So in preparing Emma for mediation, I will do the following. What is her final bargaining amount? I would want to know that. Once I hear Emma's goals, I can explain that the bottom line is never set in stone. I will also explain to Emma that the mediator cannot impose a resolution, so making a strong argument with follow-up on the negotiation would be a key factor. Preparing Emma to communicate clearly with the other side is also a key point. I need to know that she can articulate her points and pain during this time. Major considerations while preparing to present Emma's case in arbitration would be Emma sustained severe injury of second-degree burn over 15% of her body. Emma was out of work for 30 days while recovering from her burns and did not receive pay. Emma has suffered physical and mental stress from the pain of being burned and wondering if she would be disfigured for life. Emma may need additional skin grafting for her burn areas, but will take up to a year to determine that. Emma lost wages for the past month, causing some of her bills to be late. And Emma now has medical expenses due to an emergency room visit and additional aftercare visits for potential scars. I'm going to prepare Emma's case slightly different than prior mediation. I'm going to request a settlement of $200,000 less 10%. This is knowing that Mrs. Potts, and Mr. Jones do not want to go to court having this in the public eye. So I'm going to request that if they drop the case, we will drop 10% off of the initial $200,000, making it $180,000 due to the fact that Horton bit Mrs. Potts, so we're going to kind of negotiate there. And this 10% decrease will only apply if Mrs. Potts drops her case against my client for the bite to her derriere. I'm going to base my case on negligence. So as far as that goes, there's my case.